Greetings, Gil Freeman, Watch Takes Courage. Welcome to the Hive. What is the Hive, you may ask? The Hive is a place where we will discuss all things court watching in the state of Georgia. And today's topic is going to be about protective orders. Weaponizing protective orders when a shield becomes a sword. So in the interest of saving time, let's just dive right into today's topic because we don't want to take too much time on this, but I just wanted to address a few things that I observed in courts that really hurts a lot of people. So, if you had a better understanding of what was going on, you might have a better outcome. So let's get started. One of the most common questions asked by intimate partner violence advocates is, why would the petitioner lie? Well, there's plenty of incentive when you consider that in family law matters, the petitioner wants to gain possession of the home, they want to gain custody of the children, and they want to get the upper hand in proceedings. So how do you do this? Well, the first thing they're going to want to do is dehumanize the respondent so that not only the court, but the public shares little empathy or sympathy for this person. Having successfully dehumanized the respondent, the petitioner will receive an ex parte order which allows the petitioner to gain exclusive access to the home and obtain custody or modify custody of the children. This allows the petitioner abuser to isolate the children from the respondent and begin the process of dehumanizing the respondent in the eyes of the children. Now, should the respondent exercise First Amendment rights and speak out about the abusive process, the petitioner abuser will then use the temporary protective order as a gag order, which violates case law, making it illegal. If the order should at any time expire, you can anticipate that the petitioner abuser will rinse and repeat and try this again in the future. So what are some adverse effects of having an illegal protective order? Well, in the state of Georgia, the respondent cannot lease or rent property. They'll lose all state and federal security clearance. Many people believe that a protective order is a temporary thing. It's just a stay-away order, and it's not really a big deal. But in actuality, it is huge. It is for life. It follows you around like herpes on paper. Rest assured that in any future employment opportunities that involves a licensing board or security clearance, you're going to be asked about that protective order. It doesn't matter how many decades passed. It doesn't matter if it was dismissed. They're going to ask you what happened. Additionally, in the state of Georgia, while that protective order is in place, you can no longer carry a firearm. You may be subjected to substantial fines and criminal charges if you're found to have violated the protective order. And of additional benefit to the petitioner abuser, you have to spend thousands of dollars defending yourself, just further draining your resources. So when do judges abuse discretion? Oftentimes, judges will treat the allegation as the evidence, which means there's no basis in fact for what they're doing, but they do it anyway. Another instance would be when the respondent lacks the financial resources to appeal. This occurs frequently in family law because the judge will have access to financial affidavit that tells the judge right away whether or not the respondent can afford to appeal. The judge may usurp jurisdiction and venue. We'll get into the jurisdiction and venue a little later in another video, but for now, just understand that means the judge doesn't have authority to hold the hearing. Now, whether or not this is really abuse of discretion is debatable, but sometimes judges will do a 3, 6, or 12-month short-term protective order. Now, who's going to appeal a 3, 6, or 12-month protective order? It takes 9 months to appeal it, and upwards of maybe $10,000, $15,000, $20,000. So if the protective order is going to expire before it even goes through the appellate court, the appellate court is either going to side with the judge or going to declare it moot. Now, this isn't really abuse of discretion either, but a lot of times judges will render a decision in chambers or mail the decision later on. And decisions should be public. So this practice should be frowned upon. Okay, so I have an attorney. So why do I need court watchers? Judges pay attention to who's in their courtroom. To a judge, A visitor in their courtroom can be a member of the media, a member of a watchdog agency, or it could be, at the very least, a voter. But either way, judges don't like bad publicity. With the standards so low to receive injunctive relief, it's just too risky to go into a court and not have court watchers present with you. Court watchers can file for a Rule 22, a Rule 11, or a Rule 13 to record proceedings, which would just further discourage the judge from abusing discretion. Well, thank you for joining us for our first episode of The Hive. Hopefully our experiences court watching will be of some benefit to you. So thanks again, and we'll see you next time.